Hi, I'm Steve Keist. I'm a lawyer and senior partner of a 4-lawyer firm in Glendale, Peoria, Arizona.
And I'm Michael Juilfs with Fair Share Divorce. I'm a financial professional in Scottsdale, Arizona.
So, Michael, a lot of people, when they contact my office about a family law matter, are interested in the cost. And, that's a significant issue for most people. What do you see as the advantage of the collaborative law process over the cost of litigating a family law case?
In collaboration, both parties are working towards a solution that works as well as possible for both of them, whereas in litigation, it tends to be win-lose. I'm going to get more, so you're going to get less, which often can cause things to escalate. Some of the things I see that drive the cost up are, one of the big parts is what's called discovery, producing all your financial information, things like that. Sometimes people drag their feet, they don't disclose everything, they try to hide things, and that can certainly increase costs dramatically. In the collaboration process, that doesn't happen because everybody gets to see everything they want to without incurring all those costs. In addition, sometimes emotions can be a challenge, and in the collaborative process, in the collaborative process, that's why often part of the team is a communications coach that can help the parties say things in a way that can be heard by the other party and get recognition of that. Because if we can get past some of those emotional issues, then we can focus on the substantial issues of a settlement. And that's part of how you can control the costs so they don't spiral out of control as they often do in litigation.
Right. Well, and on top of the emotion driving up costs because people decide to make decisions based upon emotion rather than common sense. The other issue with the legal process is we are required as lawyers to file certain documents with the court. And part of that process, if the case is going to be litigated, requires pretrial statements and memorandums and all kinds of documents that the judges want so that they are educated ahead of time on the issues that they're going to have to decide. All of those things are, I call, churning paper. It just takes a lot of time and a lot of effort to put all these things down, make a witness list, number all those, make up copies of all those things. We don't have to do any of that in the collaboration process because we all sit down together, we disclose everything, everybody sits down and works through the paperwork at the same time rather than each party paying their own lawyer and their lawyers' staffs to do all this work separately, a lot of which is duplicative.
And Steve, it's important to recognize that just because some of those paperwork things don't have to be filed with the court doesn't mean there's less information. In fact, in the collaborative process, I would say that generally there's much more information available to both parties than we would ever see in a litigated case. And it doesn't cost tens of thousands of dollars to obtain it.
Well, and that's because if someone doesn't give me a document that you believe you need to see as the financial expert, you'll let us know in a collaborative meeting, hey, I don't see this bank statement. We need this bank statement. And I'll tell my client, we need this bank statement, rather than somebody just missing it and it never comes up. Neither lawyer realizes there's a bank statement out there they haven't seen. And that issue just gets put under the rug
or worse yet, you've got to file a subpoena and hope that the bank or financial institution complies with it.
Right.
And again, drives up costs unnecessarily.
Correct.